they did violate Mr. Janal's Fourth Amendment rights. And that is why we ask that you uphold the lower court's decision and rule in favor of the respondent. Thank you.
May it please the court, my name is Elizabeth Conway, and I, along with co-counsel Kara Howe, represent the respondent, Mr. William Janal Jr., in today's case at bar. Your Honors, the question before the court today is whether sentencing a 15-year-old boy to prison for the remainder of his life without hope of parole or rehabilitation constitutes a violation of his Eighth Amendment rights to protection from cruel and unusual punishment. And Your Honors, it does. Mr. Janal's Eighth Amendment rights were violated in two ways. First, the sentence was disproportionate to the crime he committed. And second, the mandatory sentencing procedures of Proposition 417 failed to consider the mitigating factors at hand. Your Honors, proportionality has long been recognized by this court as the means for analyzing cases in Eighth Amendment jurisprudence.
This is an aggravated rape. It wasn't, jaywalking or petty theft or a minor infraction. It was just about as serious an infraction you can get. Shouldn't the people be heard on this and their voice be recognized by the courts?
Your Honor, while we do acknowledge that, yes, Mr. Janal did commit a very serious crime here, we nonetheless maintain that the imposition of life imprisonment without the possibility of parole for a juvenile offender does constitute a disproportionately cruel and unusual punishment. And as to Your Honor's point regarding the people, we see that the enactment of this legislation in Proposition 417, which was adopted in the state of Olympus, is an error for failing to consider the mitigating factors at hand. And the Eighth Amendment, which draws its meaning from the evolving standards of decency that mark the progress of a maturing society, reveals that society views juveniles as less culpable and thus warranting lesser of a punishment than adult offenders.
Let me ask you, would you be making the same argument to me if your client were 21 as opposed to 15?
Well, respectfully, Your Honor, if our client were 21 years old, this would be a different case. Mr. Janal is only 15. A 15-year-old has been distinguished by this court for a variety of reasons. Youth of this age are at a time and condition of life where they are more susceptible to influences and they have not undergone the same cognitive brain development and maturity that marks older persons. This is different by virtue of Mr. Janal's age.
So it wouldn't be cruel and unusual that we're a 21-year-old defendant?
Well, also, Your Honor, a 21-year-old defendant would be facing a different circumstance because of the virtue of the punishment. If he were 21, it would be different. However, we're dealing with someone who's 15 years old here today, and sentencing him to life imprisonment without the possibility of parole is a different case.
Didn't we say in Kennedy versus Louisiana that punishment for a crime should be graduated and proportionate to the offense? We said that in Kennedy, didn't we?
Yes, Your Honor.
And we're dealing with, yes, he's 15 years old, but this is his third offense, and his priors are serious as well. He was convicted of shooting an air gun at passerbys at a state fair and then cruelty to animals. Why is this disproportionate given his past criminal history?
Well, Your Honor, when we look at
graduated up to ag rape.
Your Honor, when we look to the text of Proposition 417, we're punishing the crime of aggravated rape, irrespective of consideration of his past crimes. Now, this crime, while serious, is not the most serious for Mr. Janal, yet Mr. Janal is facing the ultimate penalty available.
Crimes have escalated, it seems to me, and why, is this the case that really we want to challenge Prop 17 on? Which argument be different if he had no priors? We're here, we've got two violent priors for this young man.
Nonetheless, Your Honor, we're still looking at the crime that triggered this, which was the crime of aggravated rape. And respondent would maintain that though severe, it does not warrant the ultimate punishment available for a juvenile.
Is this the ultimate?
Yes, it is.
Isn't that different? Should we analogize those cases to this case? That is different.
Your Honor, respectfully, we would say that we should analogize here because of the fact that Roper v. Simmons shows us that we cannot execute juvenile offenders. And furthermore, Coker shows us we cannot execute those who perpetrate the crime of aggravated rape. Therefore, as death is off the table, we are facing the ultimate punishment. And by virtue of the fact that Mr. Janal is 15 years old and will be sentenced to spend the rest of his life and die in prison without any chance of being reintegrated into society, this is similarly irreversible. Therefore, we would implore the court to consider this case that context. We see furthermore that now that we have established that Mr. Denault, by the fact that he is facing the ultimate punishment for less than the ultimate crime here, is also warranted to consideration of the mitigating factors at hand. And this is because of the court's ruling in Eddings. And while Eddings was a capital case, the court placed major consideration on the fact that he was a juvenile, and they applied the rule articulated in Lockett v. Ohio, which is cited in Eddings, that urges the court to give weight to the mitigating factors in any aspect of the defendant's character that would warrant a less severe punishment for the center.
But the less severe punishment in Eddings would simply be life without parole rather than death. Is that correct?
For Eddings, that's correct, Your Honor, because Eddings committed the crime of murder. However, with Denault, we're dealing with the crime of aggravated rape. So while murder may be while the appropriate punishment for the juvenile murderer may be life imprisonment without the possibility of parole, for the juvenile rapist, it is not.
Does that same inequity apply to many, many crimes, such as if one gets a sentence for life in the state of Olympus for robbery, the state has no provision for parole for many life sentences. How is it different in a non-juvenile case with respect to an adult case?
Well, Your Honor, with respect to an adult for robbery, the sentencing for that is outside of our record in the state of Olympus. However, what we're dealing with in the case of a juvenile is the stipulation of life without parole. And this is different because this is a punishment that is disproportionately severe for a juvenile offender.
You're asking the court to overrule the will of the people, the legislature. What guidelines are you proposing that we use to decide that what the will of the people of Olympus has set down are wrong? I mean, what guidelines? Give us something. I mean, you're asking us to overturn. This is a legislative act enacted by the legislatures of that. What guidelines would you have us employ to do that?
Yes, Your Honor. While we are requesting that you overturn the sentence it is a violation of Mr. Denault's Eighth Amendment rights, and while it was enacted in Proposition 417 by the people of the state of Olympus, we see that this court is not obligated to uphold an unconstitutional sentence. And furthermore, when we consider the evolving standards of decency in a maturing society,
I guess that's wrong. How do we determine the evolving sense? Do we look at what other jurisdictions have employed?
Your Honor, we have looked at what other jurisdictions have employed consistently in the cases of Atkins, in Eddings, in Coker, and Solem, and Roper. And furthermore, in some cases, this court has even considered what is applied in other countries. And if we were even to take that approach, we would see that the United States and Somalia are the only two countries in the world that practice the punishment of life imprisonment without possibility of parole for juveniles. And this is cited in the case record on page 9. Therefore, we take with this the cue from the court in Roper, which cites Thompson v. Oklahoma, to recognize that today society views juveniles as categorically less culpable than the average criminal because their susceptibility to immature and irresponsible behavior means that their conduct cannot be punished as severely as that as an adult. And Your Honors, that is exactly what's happening today. Mr. Denault is facing the ultimate punishment available. This would be the ultimate punishment available if he were an adult. And by virtue of his age and immaturity, respondent would submit that his culpability is diminished and he must be afforded the opportunity years down the line to present his case to a parole board and to have the chance to be reintegrated into society. We do not ask that the court merely sentence Mr. Denault or let him off entirely. We ask for the opportunity of parole because by foreclosing that, the state is rejecting one of the legitimate goals of punishment consistently recognized by this court in Atkins and other cases, that is to rehabilitate the criminal. Now, we don't know if Mr. Denault will be rehabilitated and will be released from prison someday. However, he must be given the chance because this punishment, we see, Your Honors, is a violation of his Eighth Amendment rights by virtue of its cruel, unusual, and disproportionate nature. And for those reasons, we ask the court to uphold the lower court's decision today. Thank you, Your Honors.
Mr. Chief Justice, and may it please the court. Opposing counsel with respect to the Fourth Amendment today argues that the Cyclops itself constitutes an unreasonable search under the Fourth Amendment. However, first, it's important to determine under this court's decision in Minnesota v. Carter whether the respondent had reasonable expectation of privacy. In fact, in order to continue with any Fourth Amendment analysis, we absolutely have to determine whether respondent Denault had a Fourth Amendment expectation of privacy. In the case of Barr, respondent Denault simply does not. Now, if we assume for a moment that the RV itself is a home, opposing counsel argues that respondent Denault derives a reasonable expectation of privacy from the recreational vehicle as a home because he's a guest in the RV, citing Minnesota v. Carter.
Well, he said it's the stepson of the owner, which is a little bit different than just being a regular guest, don't you think?
Maybe so, Your Honor, but in Minnesota v. Carter, again citing Minnesota v. Olson, this court argues that one needs to be an overnight guest in order to qualify for Fourth Amendment protection in a place that's not one's own home. And in the case of Barr, there's no indication that respondent Denault was an overnight guest. In fact, the record only specifies that respondent's stepfather and associate were overnight residents of the recreational vehicle at page 3. Now, because respondent himself is not an overnight guest or in any way an invited guest, he doesn't meet the Minnesota v. Olson criteria for an individual that is afforded Fourth Amendment protection in an area that's not his or her own home. As a result, respondent fails to meet this minimal constitutional requirement of showing a reasonable expectation of privacy under the Fourth Amendment. As a result, this court must reject respondent's Fourth Amendment argument facially and find in favor of the petition.